Welcome to the Connecticut Caselaw podcast. I'm Jay Ruane of Ruane DUI and Criminal Defense Attorneys. This week, we are covering decisions released on judicial ending the week of August 7th, 2026. Let us get into it. The next case is Bank of New York Mellon v. Moore. This is a mortgage foreclosure case out of Fairfield County. The Bank of New York Mellon, as trustee for a certificate holder trust, sued Johnny Ray Moore to foreclose on his Bridgeport property after he defaulted on a 2006 promissory note for $248,000. The trial court, Judge Sorello, entered a judgment of foreclosure by sale, found the fair market value at $451,000, and calculated the remaining debt at just over $234,000. Moore appealed, raising 4 claims. The appellate court, in an opinion by Judge Mall joined by Chief Judge Cradle and Judge Elgo, affirmed on all counts. The first claim was standing. Moore argued the bank had to do more than produce the note. The court was clear. Production of a note endorsed in blank is prima facie evidence of holder status, and that is enough. The burden then shifts to the defendant to rebut the presumption. Moore did not meet that burden, so the standing challenge failed. The second claim involved the default notice. The bank mailed the notice on November 4th, 2016, while an automatic bankruptcy stay under 11 U.S.C. Section 362 was in effect from a Chapter 13 petition Moore filed in August 2016. Moore argued the notice was void. The appellate court declined to reach that argument because Moore devoted only 3 sentences to it in his brief with no substantive legal analysis, and the court deemed it abandoned as inadequately briefed. Moore also argued the notice was never actually delivered to him. The court declined to reach that one too because Moore never raised it at trial. His post-trial brief challenged only the bankruptcy stay issue, not delivery. The court noted that even on the merits Moore would have lost, because the mortgage deed, like the one construed in Aurora Loan Services versus Condren, provides that mailing by first-class mail is sufficient and creates a presumption of receipt. The third claim was a material variance argument. The operative complaint alleged default on the note, but the proof at trial included 2 loan modifications, one from 2009 and one from 2013, that were not mentioned in the complaint. Moore argued the plaintiff was proving a different contract than the one it pleaded. The court disagreed. Both modifications contain language saying they amended and supplemented the note and mortgage, so the evidence did not depart from the pleaded cause of action. More importantly, Moore was not surprised. He did not object to the admission of the modifications at trial, and he had raised arguments about those very modifications in his pre-trial filings. No material variance, no reversal. The fourth claim was the debt calculation. The 2013 modification had forgiven roughly $322,000, bringing the principal down to about $90,000. Bank of America then issued an IRS Form 1099-C reflecting that discharge. Moore argued the court ignored that forgiveness and just adopted the plaintiff's debt affidavit, which he said improperly included the discharged amount. The court looked at the payment history admitted at trial, which showed the principal drop from $412,000 to $90,000 in July 2013 when the modification was executed. The affidavit of debt started from that reduced figure. The court found the debt calculation already accounted for the forgiven amount, and the clearly erroneous standard was not met. The practice takeaway here is straightforward for foreclosure defense work. If your client has a bankruptcy history, loan modifications, or delivery disputes, those arguments need to be fully developed at the trial level with actual legal analysis, preserved in post-trial briefing, and briefed with authority on appeal. This case is a clean example of 3 different arguments dying, 3 different deaths, one for inadequate briefing, one for failure to preserve, and one on the merits, all because the groundwork was not laid at the right stage. Do not count on the appellate courts to fill in the gaps. The next case is Crossan versus Deal. This is a tort and real property case out of Hartford, decided by Judges Elgo, Mall, and DePenema, with Judge Elgo concurring in part and dissenting in part. The dispute is a classic neighbor feud, but one with real legal complexity. The plaintiffs, Thomas and Susan Crossan, own lakefront property on Lake Wangumbog in Coventry. Their neighbors, Heidi Deal and Michael Martin, own the adjoining lot. Beginning around 2018, the relationship fell apart. The defendants placed structures, a dock, paddleboard racks, cement pavers, and banners on the plaintiff's land. They harassed Thomas in front of his grandchildren, drove a vehicle at him during a survey, and allowed guests to park on and walk across his property. The flashpoint for the emotional distress counts was an incident during the COVID-19 pandemic in which Martin walked up nose to nose with Thomas and spit on him twice while challenging him to a fight. The trial court found the defendants liable across the board. It awarded $50,000 in compensatory damages on intentional infliction of emotional distress, nominal damages on the negligent infliction, and civil assault counts to avoid double recovery, and about $2,000 in punitive damages in the form of attorney's fees on the intentional infliction and assault counts. The court also awarded $5,000 on the trespass count, calculated at $1,000 per year for 5 years, and quieted title in the plaintiff's favor based on a survey by Town Engineering Incorporated. On appeal, the appellate court reversed the emotional distress counts entirely. The court's problem was this: the trial court leaned heavily on the COVID-19 pandemic as an aggravating factor, finding that being spit on during a global health crisis would naturally create fear and anxiety about infection. But Thomas never testified that the pandemic contributed to his emotional distress. The only thing he said about COVID was that the incident happened right at the tail end of the pandemic. That is it. The appellate court applied the clearly erroneous standard and found the pandemic-related findings unsupported by the record. It rejected the plaintiff's argument that the court could simply take judicial notice that being spit on during a pandemic aggravates emotional distress. The court drew on its own prior decision in Autry versus Hosey and explained that whether the pandemic necessarily worsened Thomas's emotional distress is subject to reasonable dispute. Some people would be terrified by that risk. Others would not. You cannot presume which camp a plaintiff falls into without testimony. The contrast the court drew was sharp. In Prescott versus Gilstein, a case involving nearly identical facts, the plaintiff testified extensively about her fear of contracting COVID, her concerns about how it might worsen her multiple sclerosis, and the reawakening of past trauma. That testimony was there. In this case, it was not. Because the pandemic findings were integral to both the extreme and outrageous element of intentional infliction and the unreasonable risk element of negligent infliction, the error was not harmless. The court reversed both counts and directed judgment for Martin on those claims. The plaintiffs do not get a second bite at the apple on remand. The civil assault count survived. Martin was caught on video walking up to Thomas and spitting on him twice. The court found that established the offensive act and the imminent apprehension of offensive contact required for civil assault, and the pandemic reference in that analysis was not integral to the holding. So the assault liability stands. But because the damages on the assault count had been structured around the emotional distress award to avoid double recovery, the entire damage calculation had to be vacated and sent back for recalculation on the assault count alone, using only evidence already in the record. The trespass and quiet title counts were affirmed in full. The court credited the plaintiff's 2021 survey, found the defendants offered nothing to rebut it, and upheld both the property line determination and the literal rights finding. The $5,000 trespass award also survived, even though it covered incidents going back to 2018, which predated the formal complaint allegations. The court held that because those earlier events were actually litigated at trial, the award was proper. Here is your practice takeaway. If you are litigating an emotional distress claim and you want to use an external circumstance, a pandemic, an extreme The Connecticut Caselaw podcast is brought to you by Ruane DUI and Criminal Defense Attorneys, Connecticut's statewide criminal defense firm. We gladly accept referrals of criminal and DUI defense cases throughout Connecticut. In Fairfield and New Haven counties, call 203-925-9200. In Hartford County and Eastern Connecticut, call 860-925-9200. Always available online at ruaneattorneys.com. Now back to this week's decisions. The next case is Majkut vs. Majkut, an appellate court decision filed August 4th, 2026, decided by Judges Elgo, Seeley, and DiPentima. This is a family law case and it covers a lot of ground, so it deserves some attention. The parties divorced in December 2022. Their dissolution judgment incorporated a marital settlement agreement and a parenting plan, both signed by both parties. The plaintiff was represented by counsel. The parenting plan included a non-disparagement clause, which prohibited either parent from doing anything to estrange the children from the other parent or to injure the children's opinion of the other parent. After the dissolution, things deteriorated quickly. The defendant voluntarily relocated to Ukraine, which was actively at war. The plaintiff filed emergency motions. The court granted temporary sole custody to the plaintiff, and the defendant did not appear at the hearing. Eventually, after extensive post-judgment motions practice, the trial court issued a May 2025 order granting the plaintiff sole legal custody, setting up a visitation by agreement schedule with 30 days' notice, and finding the plaintiff in contempt for violating the non-disparagement clause. The plaintiff had created a personal website called So Much My Heart and posted on social media describing her marriage to an abusive partner without naming the defendant by name, but in ways that the court found were inferable by those familiar with the family and easily discoverable by interested or curious readers. Both parties appealed separately. The plaintiff's main argument was that the non-disparagement clause was an unconstitutional prior restraint on her speech under both the First Amendment to the United States Constitution and Article 1, Sections 4 and 5 of the Connecticut Constitution. The appellate court rejected that claim. Relying on the Connecticut Supreme Court's decision in Perricone versus Perricone, the court held that a private party who is represented by counsel and voluntarily agrees to restrict her own speech in a settlement agreement waives her First Amendment rights as to that agreement. Judicial enforcement of that contractual waiver is not the same as government-imposed censorship. The same result applied under the state constitution because Perricone had already rejected the argument that Article 1, Sections 4 and 5 prevent waiver of those speech rights. The plaintiff's argument that truth is a defense also failed because truth is a defense to defamation, not to a contempt motion based on a contractual non-disparagement clause. On the contempt finding itself, the court upheld it. The plaintiff knew about the clause, agreed to it, and the trial court found by clear and convincing evidence that she willfully violated it. The appellate court also upheld the attorney's fee award of $2,425, representing 5 hours at $485 per hour under General Statute Section 46B87, noting that contempt-related fees are restricted to efforts related to the contempt action. On the defendant's appeal, his main argument was that the trial court should not have awarded sole legal custody to the plaintiff. The appellate court disagreed, applying the deferential abuse of discretion standard under General Statutes Section 46B56. The court found the defendant's voluntary relocation to a country at war was a material change in circumstances. Importantly, the appellate court noted that the sole legal custody award did not strip the defendant of meaningful participation entirely. The order preserved his right to access the children's medical, academic, and personal records, to attend appointments, and to have reasonable digital communication with his children. The defendant also challenged the visitation by agreement structure, arguing it improperly delegated judicial authority to the plaintiff. The appellate court distinguished this situation from RHVMH and Mylott vs. Mylott, where courts had improperly given one parent the unilateral power to suspend the other parent's visitation rights. Here, the order required agreement by both parties, included a summer vacation week for the defendant, and expressly stated that the plaintiff should not thwart the defendant's relationship with the children. The court also noted that the defendant himself had previously consented to a substantially similar order, making its analysis informed by principles of induced error. The practice takeaway here is straightforward and important. If your client is negotiating a parenting plan or marital settlement agreement, a voluntarily agreed to non-disparagement clause may be treated as a contractual waiver of constitutional speech rights once it is incorporated into a dissolution judgment. Your client cannot come back later and argue it was an unconstitutional restriction on speech. The next case is Nunes versus Brown-White, decided by Judges Seeley, Wilson, and Flynn. This is a civil dispute that turned into a lesson about what it actually means to settle a case. Soledad Nunes sued Gwendolyn Brown-White and Seaview Village Condominium Association, Incorporated, over claims including invasion of privacy by false light, defamation, and negligent infliction of emotional distress. The gist of the underlying dispute was that Brown-White allegedly ran a campaign of harassment against Nunes to push her out as president of the condo board. The case got to a pretrial conference in July 2024. Nunes' attorney at the time, Attorney Angelone, and defense counsel discussed settlement terms. The next day, Attorney Angelone emailed defense counsel and said that Nunes accepts the $5,000 offer and that she agrees in principle to confidentiality, non-disparagement, a fee-shifting clause for future litigation she might lose, and a bar on running for the condo board again. Defense counsel emailed back the same day confirming those essential terms and said she would prepare a draft. Attorney Angelone then told the court's caseflow coordinator the case was settled but not withdrawn. The draft came over. Attorney Angelone acknowledged it. Weeks of follow-up emails followed asking when Nunes would sign. She never did. Eventually, new counsel came in. Attorney Angelone's appearance was withdrawn, and Nunes took the position that she never agreed to anything, and that Attorney Angelone lacked authority to bind her. The defendants moved to enforce the settlement. Judge Gould held an Audubon hearing, meaning a hearing to determine whether the terms were clear and unambiguous enough to be summarily enforced. Attorney Angelone was the only witness. He testified that Nunes had authorized him to send the acceptance email, that he would never tell opposing counsel his client agreed to settle if she had not, and that he never sent Attorney Green any proposed changes or objections to the draft. He did hedge somewhat, saying Nunes agreed only to the principles of the non-monetary terms and that the specific language was still subject to review. The court granted the motion and enforced the settlement. Nunes appealed. The appellate court affirmed on every ground. First, on meeting of the minds. The court said the factual finding was not clearly erroneous. The July 10th emails expressly stated Nunes accepts the offer. Attorney Angelone confirmed on the stand she authorized that communication. He never pushed back on the draft. The phrase subject to review of the specific language did not defeat contract formation because there was no fundamental misunderstanding about the essential terms. Under modern contract law, a binding agreement can exist even if some terms remain indefinite, and the test for disputation is applied at the moment of formation, not based on later second thoughts. Second, Nunes argued that the unsworn declaration she filed with the court showed she never consented. The court rejected that entirely. The declaration was signed but was not sworn before an officer authorized to administer oaths. It was not an affidavit. It had no evidentiary value. The appellate court said the trial court properly gave it no evidentiary value, and Nunes' failure to actually testify under oath at the Audubon hearing meant she presented no admissible evidence of her subjective intent. Third, on attorney authority. Attorney Angeloni testified multiple times that Nunes authorized him to accept the settlement. The court made no explicit finding on the authority question, and Nunes never filed a motion for articulation. The appellate court said without an articulation request, it presumes the trial court acted correctly. The implicit finding of actual authority was supported by the record. The court also noted in a footnote that Nunes was wrong on the law in any event, because Connecticut recognizes that apparent authority can also bind a client to a settlement. The practice takeaway here is about the Audubon hearing itself. If your client disputes a settlement that their prior counsel appeared to accept, you need your client to testify under oath at the hearing. A signed declaration that was not sworn before a notary or commissioner is worthless. The other side can object, and the court can disregard it entirely. If your client does not take the stand and submit to cross-examination, the only sworn testimony the court has may be from the prior attorney who said the client authorized the acceptance email, and that is very difficult to overcome on appeal. The next case is Sala v. Premier Imaging Holdings, LLC. This is an employment and business law case involving a physician non-compete clause, an arbitration award, and the question of whether a court can vacate that award on public policy grounds. Dr. Joseph Sala was a radiologist and shareholder at Radiology Associates of Hartford. In 2022, RAH sold to Premier Imaging Holdings, LLC, the equity interest of an entity that owned RAH's non-clinical assets. As part of that transaction, Sala and his colleagues received substantial payouts, including about $2.3 million in cash, and became members of a new entity called RAH Equity Holdings, LLC. They also signed an LLC agreement containing a non-compete clause that restricted them from practicing radiology for 2 years within a territory defined by specific hospitals and imaging centers, plus a 25-mile radius from each. After Sala gave notice that he was resigning and would begin working for Radiologic Associates of Middletown, the defendants demanded arbitration. The arbitrator issued a 2-sentence award declaring the non-compete valid and finding that Sala's employment with Radiologic Associates of Middletown before June 9, 2026, would be a breach of the agreement. Sala went to the Superior Court to vacate the award. Judge Clow granted the application, finding the award violated public policy embodied in General Statute Section 2042, and also that the arbitrator manifestly disregarded the law. The defendants appealed. The appellate court, in an opinion by Judge Westbrook, joined by Chief Judge Cradle and Judge Wilson, affirmed. The court focused on the public policy ground and did not reach the manifest disregard issue. Section 2014P, enacted in 2016, sets hard caps on physician non-competes. No more than 1 year in duration, and no more than 15 miles from the physician's primary practice site. The non-compete here ran 2 years and extended 25 miles. Both limits exceeded what the legislature determined was reasonable. The court applied a 2-step public policy analysis. First, it asked whether the award implicates an explicit, well-defined, and dominant public policy. The answer was yes. The court pointed to both the long-standing common law disfavor of unreasonable restraints on trade and to Section 2014P itself, which it described as the legislature expressly quantifying the outer limits of reasonableness rather than leaving that to courts. Second, it asked whether the contract as construed by the award actually violated that policy. Again, yes, because enforcing a 2-year, 25-mile restriction on a Connecticut physician directly contradicts what the statute permits. The practice takeaway is this. If you represent employers or private equity groups acquiring physician practices in Connecticut, non-compete clauses in transaction documents should be drafted to comply with Section 2014T. The court applied the statute to the covenant in the 2022 LLC agreement. And this case shows that even a final arbitration award upholding such a clause can be vacated if it sanctions restrictions that exceed the statute's 1 year and 15-mile limits. Draft to those limits from the start, because courts will not enforce your award if you do not. That is all for this week's Connecticut Caselaw podcast. New episodes every Friday. Subscribe wherever you listen to podcasts, give us a 5-star review, and we will see you next week. This podcast is for informational purposes only and does not constitute legal advice. This episode was written and voiced using artificial intelligence. Please read the full opinions yourself before relying on anything discussed here.